Dear friends, for the first time in the history of India, a motion for impeachment of the Chief Justice of India was given by the opposition parties. The Vice President of India, who is also the chairman of the Rajya Sabha, rejected the motion. But the opinion is strongly divided about this action. Iqbal Amrohi in this audio blog has collected the opinions of the supporters as well as opponents of rejection of this motion. The title of this blog is "Who Said What About the Impeachment of Chief Justice of India?"
Dear friends, the Chief Justice of India, CJI, is the head of the Judiciary of India and the Supreme Court of India. Article 124 Section 4 of Constitution of India lays down the procedure for removal of a judge of Supreme Court, which is applicable to Chief Justice as well. Once appointed, the Chief Justice remains in the office until the age of 65 years. He can be removed only through a process of impeachment by Parliament as follows. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. A removal motion signed by 100 members of Lok Sabha or 50 members of Rajya Sabha has to be submitted to the Speaker of the Lok Sabha or Chairperson of the Rajya Sabha, who is also the Vice President of India. This can be in either of the houses of the Parliament. The Speaker or Chairperson can then either accept or reject the motion. The present Chief Justice of India, Justice Deepak Misra, is the 45th CJI since January 1950. He succeeded Justice Jagdish Singh Khara on August 28, 2017. And will remain in office until October 2, 2018, the day he retires on turning 65 years in age. As many as 64 members of the Rajya Sabha belonging to 7 political parties signed the notice for removal proceedings against Chief Justice of India Deepak Misra. These parties include Congress, the NCP, CPM, the CPI, the SP, the BSP and the Muslim League.
After the notice of removal of the Chief Justice of India was submitted to the Vice President of India and Rajya Sabha Chairman Mr. Venkaiah Naidu, he consulted many legal and constitutional experts. The consulted persons include former Lok Sabha Secretary General Subhash Kashyap, ex-Law Secretary P.K. Malhotra, former Legislative Secretary Sanjay Singh, former Supreme Court Judge B. Sudarshan Reddy, current Attorney General K.K. Venugopal, former Rajya Sabha Secretary General Vivek K. Agnihotri, and former Attorney General Soli Sorabji, Mukul Rohatgi and K. Parasaran. He also held deliberations with senior officials of the Rajya Sabha Secretariat. He, however, did not consult the CJI since the motion pertained to him. Mr. Venkaiah Naidu rejected the notice to remove the Chief Justice of India, CJI, Deepak Misra on April 23, 2018, saying it lacked substantial merit. Mr. Naidu said, having considered the material contained in the notice of motion and reflected upon the inputs received in my interaction with legal luminaries and constitutional experts, I am of the firm opinion that the notice of the motion does not deserve to be admitted. Accordingly, I refuse to admit the notice of motion. He added, I have applied my mind to all 5 charges made out in impeachment motion and examined all annexed documents. All facts as stated in motion don't make out a case which can lead any reasonable mind to conclude that CJI on these facts can be ever held guilty of misbehavior.
Former Law Minister and Congress leader Kapil Sibal termed Mr. Naidu's rejection of the impeachment notice as illegal and unconstitutional. Mr. Kapil Sibal told reporters that Mr. Naidu's order jeopardized the country's legal system and said that the government was not keen to see a probe into the case. The order had shattered the confidence of the people and jeopardized the legal system, he added. The order destroys the legitimate processes of the law. It seeks to ensure that no inquiry takes place, he added. It is illegal because the chairman has passed an order which is required to be passed after a full-fledged inquiry, Sibal said, adding that the Rajya Sabha chairman had to only ascertain whether the motion was in order. Proved misbehavior comes after the inquiry. The order is illegal because the chairman has said that we have not been able to prove misbehavior. How can something be proved before it is proved? It cannot be proved before an inquiry. The order is also ill-advised as the chairman should have consulted the members of the collegium. He has not chosen to do that, said Sibal. Sibal also wondered why the chairman passed the order in a tearing hurry, as to any normal person it should have taken days of consultations to arrive at a decision on such a momentous matter. We will certainly move the petition in the Supreme Court. We are confident that when we move the petition, the CJI will have nothing to do with it so that it is heard and the serious issues, which are constitutional in nature and which will determine whether we bring transparency to the system, would be heard in the court, Sibal said. Congress President Rahul Gandhi, addressing a gathering to mark the party's Save the Constitution campaign, accused the Modi government of crushing and suppressing the Supreme Court and asserted that his party would not allow the ruling alliance to derail institutions created by the Constitution. Our institutions were gifted to us by our Constitution, he told the participants of a Congress rally in New Delhi. The Modi government is now destroying these institutions by appointing RSS ideologues to occupy important positions. It has happened for the first time that 4 judges of the Supreme Court went to the people to seek justice. The Supreme Court is being crushed, it is being suppressed. Parliament was not allowed to run, he said. He alleged that people with the RSS background were being inducted into various institutions by the BJP-led government. CPI-M General Secretary Sitaram Yechuri slammed Mr. Naidu's decision to reject the opposition's impeachment motion against Justice Misra. I am sorry to say that about the Honorable Vice President and Chairman of Rajya Sabha, but I think that the methods, that had been very clearly laid down, both in the constitutional procedures and the rules, have not been followed, Mr. Yechuri told news agencies. Mr. Yechuri said that the presiding officer of either house, in which the impeachment motion has been moved, does not have the discretion to independently decide about the validity of the motion. Instead, the motion needs to be referred to a 3-member committee, which normally should include a Supreme Court judge, a High Court Chief Justice, and a jurist. Mr. Yechuri said that if that committee gives the findings, saying the impeachment motion is untenable, then the chairman could have taken the decision. Mr. Rajaramachandran, senior advocate and former additional solicitor general, told the Hindustan Times on April 24, 2018, that the notice of motion for the removal of the Chief Justice of India should have been sent to a committee for examination. I don't think the chair was justified in going into the merits of the charges. The order uses phrases like not verifiable, but verification can only happen at the stage of inquiry, he said. Mr. Ramachandran, who served as the counsel for the Justice Sawant Committee, set up when a removal motion had been admitted against Justice V. Ramaswamy in 1991, added, "The chair has made the same mistake that many commentators have made in recent days, that the notice must be based on proven misbehavior. The motion is only required to cite instances of misbehavior and, if it exists on the face of it, then it calls for an inquiry. Proven misbehavior is the ground for removal, not a precondition for a motion to be admitted." Senior advocate Mr. Sanjay Hegde said he disagreed with the Congress-led opposition's move to give the notice, but once it was given, the chairman of the upper house should have admitted it. Mr. Hegde argued it would have been better to let the matter play out, go to a committee, and the committee may well have concluded that the charges did not hold. Ms. Huzefa Ahmadi, another senior advocate, argued that the chair may have overstepped his jurisdiction. The jurisdiction of the chair to adjudicate the motion on its merits is extremely limited. My personal view is he has transgressed the limits of jurisdiction. Ms. Ahmadi said that the chair's order speaks of taking into consideration various views and articles in recent days. Mr. K.T. Tulsi, senior advocate of the Supreme Court and member of the Rajya Sabha, opined that the Vice President, as ex officio chairman of the upper house, has to only consider whether the motion is valid or not at this stage. Mr. Prashant Bhushan, the senior lawyer, Supreme Court, said, "The Vice President has no power to say that charges are not made out. That is for an inquiry committee of 3 judges. He only has to see if it is signed by 50 MPs and, possibly, if charges are of misbehavior." Senior advocate Mr. Ashok Ban argued that the Vice President ought not to have rejected the motion at the initial stage. The only thing the VP can look into at the admission stage is whether those signed are MPs and there are adequate numbers for the motion and process it. He cannot go into the merits of the allegations, as it is not his domain, as it should be established only after a proper inquiry. Mr. Faizan Mustafa wrote in Indian Express on April 24, 2018, that both the chairman of Rajya Sabha and Speaker of Lok Sabha must conduct themselves in such a manner that their actions demonstrate their utmost impartiality. In deciding on an impeachment motion, the Vice President should not ideally take over the role of the inquiry committee, and pass judgment on the allegations. For the first time in Indian history, an impeachment motion has been rejected at the admission stage. But at the same time, as the presiding officer, the Vice President is not supposed to mechanically admit any motion just because it has been signed by the requisite number of members.
On the other hand, after the motion was rejected by Mr. Naidu, The BJP president Mr. Amit Shah lashed out at the Congress party, saying the opposition's move was part of a larger trend to demonize and weaken every institution that seeks to maintain its individual identity. The BJP spokesperson, Mrs. Meenakshi Lekhi, accused the Congress of adopting intimidatory tactics towards the Supreme Court. Mrs. Lekhi said the Congress move was not an attack on the individual but an institution, as it wanted to create anarchy by making people lose faith in the judiciary. She claimed that the Congress was trying to create an impression in the world that India was a banana republic. She added that the country's institutions were very strong and commanded the reverence of its people. Union Finance Minister Arun Jaitley had said that the notice was a serious threat to judicial independence and an attempt to intimidate a judge. Eminent jurist Soli Sorabji on April 23, 2018, told PTI that the Congress-led opposition had no chance to succeed in the Supreme Court against Vice President M. Venkaiah Naidu's decision rejecting impeachment notice against Chief Justice of India Deepak Misra. The former Attorney General of India said that the Rajya Sabha chairman has applied his mind after consulting legal experts on the issue. The Vice President has applied his mind. He has consulted legal experts and has come to a decision. We did not want the matter hanging indefinitely, he said. Senior jurist Fali Nariman said the chairman of the Rajya Sabha was the only statutory authority to take the decision on the notice. He pointed out faults in the impeachment notice, saying, "It has to have something that is far more important than just saying he did not do this or that. This order, however, can be challenged in court," he said. "This is a horribly black day. The blackest possible day. I've never seen a day like this. In my 67 years, I've never seen a day like this," Mr. Nariman said in an exclusive interview to the Sunday Express. He pointed out that the charges brought by the Congress-led opposition were not in line with what the foremost senior judges, Justices Jaschi Keelamizwar, Ranjan Gogoi, Kurian Joseph and Madan Lokor, stated in their press conference on January 12, 2018. The jurist pointed out that one of the most serious consequences of the opposition's move to impeach the Chief Justice would be to encourage the government to bring charges before any judge whom they disliked. "Suppose I am a judge and I have a cast iron case against the government. But I will be very fearful to decide against the government in a politically charged case. If members of the ruling party don't like a particular judgment, suppose the Ayodhya case, the Babri Masjid Ram Janmabhoomi land title, goes against them and the SC says this land belongs to Muslims and not Hindus. Suppose this happens. I am not saying it will, but suppose. Are they going to impeach the judges?" he said. Former Secretary General of Lok Sabha, Subhash C. Kashyap, who is believed to be one of the experts consulted by Naidu before he took the decision, said, "I have throughout maintained that this notice for the impeachment motion against the Chief Justice of India was unsubstantiated, politically motivated and not based on sound facts, and so it deserved to be rejected outright." Former two-time Union Law and Justice Minister Ram Jethmalani also has backed the Vice President of India rejecting the opposition's impeachment motion against the Chief Justice of India, saying that there are even stronger reasons why it should have been rejected.
The Hindu newspaper wrote an editorial titled "Unprecedented Crisis" on independence of the judiciary on April 23, 2018. It wrote, "These are extraordinary times for the judiciary. From signs of a confrontation with the executive over judicial appointments to an unpleasant rift among Supreme Court judges, it has seen much turmoil recently. The process initiated by major opposition parties to impeach the Chief Justice of India is an unprecedented crisis. Their main charge is that CJI Deepak Misra selectively assigns cases to benches of his choice. The CJI has stuck to his position that as master of the roster he has the prerogative to allot cases. But this still raises the question, could the CJI have better addressed his colleagues' concerns and put in place an informal consultative system, so the damage the institution has suffered could have been avoided? The movers of the motion do not have the numbers to get it passed. And it is wholly within the power of Vice President and Rajya Sabha Chairman M. Venkaiah Naidu to decide whether to admit it. Against this backdrop, the impeachment attempt led by the Congress may be perceived in some quarters as no more than a political move to highlight its claim that key democratic institutions are in danger under the present regime." End quote. The Hindu editorial succinctly summarizes the whole issue of the impeachment of the Chief Justice of India. The fact is that an impeachment motion has never been moved against the CJI. This is the first time that such a thing happened in India. Without going into the details about who is responsible for this, I can only state that it was really sad that a motion was given for impeachment of the Chief Justice of India.
Thank you for watching. Please like and share this video. Your comments are highly valuable for us. Please give your opinion about this content. Please subscribe to this channel. If you subscribe to this channel, you will receive notifications as soon as any new video is uploaded on this channel. Thank you once again.